Hillary, who, as I mentioned, is a professor at the University of Massachusetts School of Law. She presented nationally and internationally on the domestic use of unmanned aircraft systems. Her article on the subject, Eye in the Sky, Constitutional and Regulatory Approaches to Domestic Drone Development, was the lead article in the fall 2014 issue of the Syracuse Law Review. She's a contributing author to the ABA's forthcoming publication, Unmanned Aircraft in the National Airspace, Critical Issues, Technology, and the Law. Her focus is on public and private use of unmanned aerial systems and constitutional, legislative, and regulatory constraints that apply to this important emerging technology. So, Hillary.
Thank you, Kirk.
You got that one?
Let me turn this on, yeah.
You got it really close, but it was earlier.
Says on.
Yeah,
Yep.
I can hear you.
Good, okay, fantastic. Good morning, everybody. Nice to see you. Thank you again, Kirk, for inviting me to be here. It's a pleasure to speak to you all. I don't think I need to tell this audience that unmanned aircraft systems is an industry that is rapidly growing and prosperous with a variety of civil and commercial applications. I suspect you already know that, as well as predictions around the number of unmanned aircraft systems that are anticipated to be in our national airspace by the end of this decade. And even moreover, you've probably read the financial projections regarding UAS and the type of economic growth that's anticipated as these aerial vehicles proliferate in our society. Of course, all of this assumes that the regulatory and statutory schemes allow UAS to be ubiquitous in the skies. And that's likely one of the reasons that you came here today, is to learn a little bit about the statutory and regulatory structure that presently exists, and to look a little bit toward the future in understanding where things are headed. So my task today is to give you a current picture of that regulatory and legislative landscape for UAS. And because there is so much movement on both fronts, legislative and regulatory, it's quite possible that some of the information that I tell you about today will even be outdated by the end of the month. So first, safety and privacy are probably the two main foremost concerns regarding UAS. And safety is solidly in the domain of the FAA. And I can tell you without a doubt that privacy is the #1 concern among lawmakers. The FAA has jurisdiction over our national airspace. And in 2012, likely most of you, if not all of you, know that that Congress directed the FAA to establish guidelines to help integrate UAS into our national airspace, with giving them a deadline of September 2015. Meanwhile, while that regulatory process and those proposed rules are moving their way forward, the FAA controls who and what UAS can operate in our national airspace. There is a process for obtaining permission or authorization from the FAA to use unmanned aircraft. Depending on the kind of operator you are and the type of UAS you want to use, that's either going to fall under something called a certificate of authorization or an airworthiness certificate. Now, I'm not going to get into the details of airworthy certificates and exemptions and whatnot, because one of our speakers, John McGraw, is going to address that in a lot more thoroughness. But what I can tell you is that prior to September 2014, authorized users of UAS were almost exclusively public entities. These included the FBI, the Department of Defense, departments of wildlife, fish and game, forest services, and even some public universities for research and development purposes. And then there was one private industry, BP, right? BP was given authorization to use UAS in the Alaskan wilderness to monitor the pipeline. And then something pretty interesting and sort of exciting happened. In September 2014, 6 Hollywood-based film companies were granted permission by the FAA to use UAS. but it came with a variety of restrictions. Some of them include that the unmanned aircraft was not allowed to fly or is not allowed to fly above 400 feet, can only be used during the daytime, only allowed to be used on sets that are closed to the public, and must be operated by a technician with a pilot's license. Now, after September, after these authorizations were made, many commercial users and advocates thought and anticipated that the FAA was broadening commercial use for UAS. And then things were sort of quiet for a little while. And then on February 15th of 2015, the FAA issued the much anticipated proposed regulations for small UAS, right? You are essentially familiar with that event. And one of the things that I want to do in my talk is to just talk a little bit about some of the highlights of these proposed rules that might be of most interest to you, skipping over some of the more smaller details. But obviously, if this is something that affects you and your business, I can give you sources for looking at these specific proposed rules in a much more detailed way. But basically, the FAA chose to focus on a category of UAS that posed the least threat to our national airspace. And that would be UAS under 55 pounds, the small UAS. And in a global sense, what these proposed rules are going to do is they're going to lift what's been thought by many, probably most of you in this room, as a rather burdensome requirement of having to receive from the FAA an airworthiness certificate or be exempt from that. The other thing that these proposed rules, or another group of operators that these rules do not apply to, are hobbyists and recreational users. But they also don't or are not intended to apply to government users. Government users, public entities, it is still anticipated that they will go through the existing process for authorization from the FAA, which is essentially a certificate of authorization from the FAA, which would give them more leverage and fewer restrictions. Okay, oh, sorry. But for the rest of us, everyone else seeking to operate a small UAS for commercial purposes, there are operational limits and there are requirements for operator certification. Let's talk briefly about the operational limits. An operator must maintain a visual line of sight at all times, may not fly over people that are not directly associated with flight. There are limitations with respect to altitude as well as speed. The UAS is not permitted to fly above 500 feet and may not exceed a maximum speed of 100 miles per hour. It's prohibited from operating in restricted airspace and flight paths near airports. And it must see and avoid all manned aircraft. And the UAS must display standard aircraft registration markings on it. Now, with respect to operator certification, in order to get a small UAS license, an operator must be at least 17 years of age, must pass what's called an aeronautical knowledge test, which is essentially a written exam that would be given at an FAA testing center, with a requirement that this exam be taken every 24 months, sort of for reauthorization, and undergo what is referred to as a vetting process with the TSA. Now, there are no other pilot certifications, such as a private pilot license or anything of that kind, that's required under these proposed rules for operator certification. The link that's up there on the slide for the regulations, it's an excellent site for really a very, very comprehensive, detailed report of the proposed rules and a lot of information pertaining to the proposed rules, including this chart, which I thought just might be of interest to some of you because the FAA has estimated some of the anticipated costs associated both with the the operational limits as well as the operator certification requirements. Some of you just may be interested in the bottom line with respect to total cost. But again, this kind of information and information that literally goes into every one of the provisions that the FAA has anticipated costs for can be found at that site. Let me just put that back up there in case anybody wants to jot that down. So the public comment period on these rules, it began on February 23rd of 2015, and it closed on April 24th, 2015. The FAA received 4,534 comments, all of which you can find on the FAA's website if you should desire to do so. One particular comment that I thought this audience might be interested in was from the Small Business Association. And I noticed actually on my way in here today that it looks like the Massachusetts Association of Small Businesses is actually housed in this particular building. But this was from the U.S. Small Business Association, basically calling for the FAA to better define their risk framework and risk parameters so that innovators could design and build technologies better suited to those concerns. The FAA is also considering developing a second classification of UAS, a micro UAS classification with its own set of proposed rules, and those would pertain to UAS that are 4.4 pounds or lighter. Okay, it's anticipated these proposed rules are not in effect. It's anticipated that they will not be in effect in whatever form they ultimately take until at least the end of 2016 or 17. I don't know if that's something that all of my panelists and I agree about, but those are some of the predictions that I have read. And that in part is due to the fact that there was such a large number of public comments that the FAA received and is sifting through. And what kind of tweaking happens from there, we'll just have to wait and see. But the FAA anticipates that the type of operations under this framework will include things like aerial photography and crop monitoring and inspections of antennas and power lines and pipelines and refinery equipment. Because again, there are certain types of commercial activity that may very well not fall well within the constraints of even these proposed rules, particularly with respect to the altitude limit. So in the meantime, while we're waiting for these proposed rules to make their way through to ultimate promulgation, industry analysts worry that any incidents with UAS in the public, whether it be unmanned aircraft that are flying too close to the White House, or near misses between manned and unmanned aircraft, may very well cause some potential interruption or hiccups toward the final regulations for these proposed rules. So just a quick, I got to go over here to do this. Just a quick story from last week that I'll play for you right now related to that subject.
It's the Marketplace Tech Podcast for Friday, May 15th. I'm Ben Johnson in New York. For the second time this year, an arrest has been made following a drone buzzing too close to the White House. The Secret Service detained a man who was trying to fly a remote control vehicle over the fence. With FAA regulations for commercial drone use in the air, it's a delicate moment for unmanned aerial vehicles, which makes us wonder about the role of manufacturers. Brendan Schulman is head of the Unmanned Aircraft Systems Practice at law firm Kramer Levin. Hi, Brendan.
Hi.
Is there anything else that this particular news has you thinking about as someone who's working in this space?
So I think the incident is really indicative of the ineffectiveness of a regulatory approach to this challenge. In other words, putting into place restrictions on commercial use is really not going to stop somebody from intentionally going somewhere and flying a drone for a malicious purpose. That's really a security and police type of situation. And incidents like these really should not be used to hold back the amazing benefits.
Brendan Schulman is head of the Unmanned Aircraft Systems Practice at the law firm Crane.
So a tenuous time, I think, for these proposed rules in terms of there's a long stretch with a lot of opportunity in between now and then. And the hope is, obviously, I would suspect that many of you would share this view, that we would think that whatever kind of incidents arise between now and anticipation of these proposed rules being made final, that things that are occurring in our airspace are not going to interfere with the eventual finalization of these particular regulations. Now, what I want to do now, if I may, is turn to what things look like on the federal level. I briefly want to talk about some of the legislation afoot that might be, that certainly would be impactful, but also may be something that some of you at least want to be aware of, if not follow. You likely know that to date, there are no federal laws specifically regulating unmanned aircraft systems. What we have essentially are the FAA regulations, but those are really focused on assuring safety in national airspace. Nevertheless, there have been 4 or 5 different bills proposed in Congress, ranging from Rand Paul's moratorium of drone use to a more precise framework developed by our own Senator Ed Markey's bill called the Drone Aircraft Privacy and Transparency Act. And I wanted to spend a couple of minutes talking about this legislation because for a couple of different reasons. Number one, it's probably the most comprehensive bill before Congress. It was initially introduced in Congress in March of 2013, but it was just reintroduced in early March of 2015 by Senator Markey. And not only that, but many of the aspects of the legislation appear in many of the state proposed and enacted bills. And it very well may have an impact on some of the work that you do. So just briefly, the Markey legislation, DAPTA, basically focuses on 2 things: the gathering of information as sort of one subset, and the retention dissemination of the information collected by the UAS as sort of a second subset. So with respect to the gathering of information, the legislation proposes that before an operator be authorized to operate the UAS, that in order to get a license, information would have to be disclosed about the flight path, the purpose of the operation, where the type of data that is going to be collected or anticipated to be collected, and how that data will be used going forward. And then with respect to the retention and dissemination of information, once the information is gathered, how long will it be kept? Where will it be stored? And equally important, will it be disseminated and to whom? Restrictions on the sharing of information, leasing, selling, because a lot of this data with anticipation is valuable information that and constraints on how it's disseminated is a major part of this legislation. Along with those things, the proposal in the legislation is that information would be available in a publicly searchable database with disclosures about any data security breaches. And with respect to law enforcement, that law enforcement issue what the legislation refers to as a data minimization statement. This is essentially law enforcement explaining how the agency will minimize the collection of information that is well outside the bounds of their target of the investigation. Now, on the state level, things look very, very different than they do on the federal level. And what I mean is that states have responded much more quickly than federal lawmakers toward restricting the scope and use of unmanned aircraft. Since 2013, there has been really significant momentum among states to regulate UAS. And this has been a really interesting and difficult thing to monitor because literally this is changing from week to week. And the number of bills that are being initiated in state legislatures around the country is kind of mind-boggling. Now, what's driving all this? Privacy concerns. Okay, and you know that just from the titles of the legislation themselves. They evince strong privacy concerns. For instance, Illinois, their bill is called, and it's an enacted piece of legislation, Freedom from Drone Surveillance Act. Florida, their bill, their enacted law is referred to as the Freedom from Unwanted Surveillance Act. Vermont has proposed legislation, not enacted, and its title regarding regulation of UAS is an act relating to privacy protection. And this is equally true on the federal level in terms of concerns that the White House shares. Because interestingly, I don't know how many of you know this, but on the same day that the FAA issued their proposed rulemaking on February 15, 2015 for small UAS, the White House issued a memorandum and it was on the very same day, titled "Promoting Economic Competitiveness While Safeguarding Privacy, Civil Rights, and Civil Liberties in Domestic Use of Unmanned Aircraft Systems." Basically, that memorandum called on all federal agencies to develop clear rules to protect privacy and civil liberties of Americans. So, privacy is the number one driving force among lawmakers when it comes to the proliferation of UAS. So what does this look like on the state level? Right now, today, there are 17 states that have passed laws which range from moratoriums on UAS to basically laws that prohibit law enforcement officials from using a drone without first obtaining a warrant, to restrictions on private individuals using UAS to collect and capture images of other people without their consent. The most recent law was passed just on May 14th of this year in Florida. Florida had, since 2013, an enacted statute that just regulated government public use of UAS. And the governor there, just on May 14th, signed into law an amendment of that existing legislation, which essentially restricts the use of private individuals from using UAS under certain circumstances. So, like I said, this is something that literally is changing from week to week in terms of the legislation that's being proposed and the legislation that's being enacted. Just this year alone, we've already seen 33 states that have proposed new legislation on unmanned aircraft system, which is really rather astonishing. And when you dig a little deeper into this, which I'm going to get to momentarily, where you see the, sort of what states are focusing on here in terms of restrictions on public versus private or both, it's really quite interesting. But just to give you a sense of let me just mention, how many states in the country have either enacted or passed legislation on UAS? All but two, okay? All but two. Delaware and South Dakota are the only two states that haven't, now I want to say this carefully, proposed or enacted legislation. Some of the legislation's been unsuccessful, but those are the only two states that haven't even put forth any legislation here. I'll show you that map in a moment. But let me just give you a really, broad strokes here. The issues that are addressed in this legislation really range from defining UAS to the permissible uses by law enforcement agencies to constraints on private use, which can vary from altitude restrictions, line of sight restrictions, consent from those whose images are being recorded. Some states impose only civil penalties. Some states impose criminal penalties, barring use of evidence in trials, reporting requirements, retention requirements, and dissemination requirements. So really, really spans the gamut of different things. Now, let me just talk about this map for a moment. So, first of all, this map depicts what I just told you, which is only 2 states that haven't proposed or enacted any kind of UAS legislation. But more specifically, the states with the enacted legislation are in blue and maroon. And I distinguish the states with restrictions on private use versus public use. So the blue are the restrictions on public entities using UAS, and the maroon are the restrictions on private use. So among the 17 states that have enacted legislation on UAS, 10 of those states have restrictions on private drone use, so pertaining to private individuals using unmanned aircraft. Like I said, the most recent one being in Florida, which provides a civil cause of action if somebody records somebody's image under particular circumstances without their consent. Now, this is interesting because we're seeing more and more legislation moving toward restrictions on private use. 6 months ago or a year, I was giving this talk, we would have seen maybe 3, 4 states with any kind of private use restrictions. But with the proliferation of UAS nationwide, more and more states are moving toward concern over restricting use of unmanned aircraft systems. This map shows the states with both the enacted and, in the orange, the pending restrictions on private use. And like I said, they run the gamut of all different kinds of restrictions. Besides Florida, I'll just touch on a few. In Hawaii last year, 2014, they amended their violation of privacy statute by making it a criminal offense for anyone to use a, quote, drone for commercial or business purposes to conduct surveillance, eavesdrop, peep into windows, or any opening of a dwelling for purpose of spying on occupants or to track or record specific persons without their consent. Arkansas, earlier this year on March 2nd, amended its voyeurism statute to include unmanned aircraft, making it a crime for anyone to knowingly use a UAV to surreptitiously film or record or photograph another person without their knowledge or consent. California recently amended its anti-paparazzi law to ensure that it covers images and recordings that are captured by UAS. I think this is really quite interesting. Then we have immunity from liability for causing harm to an unmanned aircraft. This is out of Oklahoma. I think this sort of reminds me of what happens if you shoot down the drone. Oklahoma has a proposed law. Any person owning or controlling real estate or other premises who voluntarily damages or destroys a drone located on those premises or within the airspace of those premises, not otherwise regulated by the FAA, shall, together with any successors in interest, if any, not be civilly liable for causing the damage or destruction to the property of such person. That's a new one. We'll have to follow that and see where that goes, right? But a lot of people have asked me, what happens, what rights do I have if there's a drone buzzing about my property and I damage it? Well, if you're in Oklahoma, that may be good news for you. So one last thing, because my time is almost expired. I think it's important to just tell you a little bit about the Massachusetts legislation that is currently pending. Essentially, there are 2 bills in the Massachusetts legislature that I think you want to know about, and they're identical. Senate Bill 1835, the chief sponsor of that bill is Senator Robert Hedlund, and House Bill 1322, the chief sponsor of that bill is Colleen Gary. Now, important to know, this legislation, both these bills, only regulates public government use of UAS. It has no restrictions, doesn't touch on the issue of private use of UAS at all. But just a couple of things about this, if this is an area of interest to you. Essentially, it proposes to require the police to first obtain a warrant before using an unmanned aircraft, to collect data that is only the subject of the warrant and avoid data and information collection pertaining to individuals and homes and other areas that are outside the scope of the warrant. specifically has language that prohibits biometric technologies, specifically facial recognition technology, to be used in any way except to identify the subject of the warrant. In terms of the retention of information, this is interesting and differs from a lot of other states. The bill proposes that the data that's collected, other than the information that's subject to the warrant, shall be deleted within 24 hours. How they're going to monitor that and enforce that is a curious thing, but it's a 24-hour retention requirement, and it prohibits any kind of weaponry on board the UAS. Okay, so that's it for me. Happy to answer more questions in the Q&A. I think, although there's a question, Kirk, how do you want to handle questions?
Yeah, let's wait till the end.
Okay, all right. Thank you very much.